Question 501. A bank loan officer was referred a client by a real estate agent. Then, the loan officer sent the agent $100 in cash as a present. The agent should return the money because it is unlawful to accept it, under the provisions of A. RESPA, B. The Rumford Act, C. Regulation ZD. The agent can accept the money, there's no law against expressing friendship. Correct answer is A. RESPA. The Rumford Fair Housing Act, in California, prohibits discrimination in the sale or rental of housing based on race, color, religion, sex, marital status, national origin, ancestry, familial status, disability, or source of income. It doesn't directly address kickbacks or referral fees in lending. Regulation Z implements the Truth in Lending Act, TILA, and focuses on requiring lenders to disclose the terms and costs of credit to consumers. While it aims for transparency in lending, it doesn't specifically prohibit referral fees or kickbacks between settlement service providers. RESPA prohibits kickbacks and unearned fees in federally related mortgage loan transactions. The $100 cash, present, from the loan officer to the real estate agent for the referral is considered an illegal kickback. RESPA aims to prevent hidden fees and ensure consumers have transparent and fair settlement processes. Accepting such a payment creates a conflict of interest and can lead to steering consumers towards certain service providers based on personal gain rather than the best interests of the client. While expressing friendship is generally acceptable, the context of a referral in a real estate transaction involving a federally related mortgage loan makes this present fall under the prohibited kickback provisions of RESPA. The law recognizes that such payments can influence professional recommendations and harm consumers. Question 502. After filing for Chapter 11 bankruptcy protection, a corporation's board of directors had no plan for handling the firm's reorganization. How long from this point in time until creditors can present their own plan? A. 1 month, B. 90 days, C. 120 days, D. Immediately, since management's failure to fashion their own reorganization plan gives creditors the right to present theirs right away. Correct answer is C. 120 days. Under Chapter 11 of the U.S. Bankruptcy Code, the debtor, in this case, the corporation, has an initial exclusive period during which only they can file a plan of reorganization. This exclusivity period is typically 120 days from the date of the bankruptcy filing. If a debtor doesn't file a reorganization plan within 120 days, or if creditors don't accept it within the following 60 days, the debtor loses their exclusive right to propose a plan. After this 180-day exclusivity period, creditors can then submit their own reorganization plans for the debtor's business. Since the corporation's board of directors has no plan at this point, the creditors must wait out the initial 120-day exclusivity period before they can file their own plan. The court can lengthen this period at management's request, but will eventually pass control of the firm's affairs over to creditors. Question 503. The types of remedies for breach of contract. A. Specific performance, B. Damages, C. Lee pendens, D. Either A or B. Correct answer is D. Either A or B. Lee pendens is a notice filed in the public records to warn potential buyers or lenders that there is a lawsuit pending that could affect the title to the property. It's a notice of a legal action, not a remedy for breach of contract itself. Specific performance is an equitable remedy where a court orders the breaching party to fulfill the terms of the contract. It's typically used when monetary damages are inadequate, such as in real estate contracts where the property is unique. Damages is a legal remedy where the non-breaching party is awarded monetary compensation to cover the losses they incurred due to the breach. There are various types of damages, such as compensatory, consequential, and sometimes punitive. Question 504. Prima facie means. A. First in priority. B. Primary evidence. C. Main balance. D. Principal. Correct answer is B. Primary evidence. Prima facie is a Latin term that literally means, at first sight, or, on its face. In legal contexts, it refers to evidence that is sufficient to establish a fact or raise a presumption. Essentially, it suggests something is considered true unless proven otherwise. It's considered primary evidence because it's the initial evidence presented that, if not challenged, would prove a particular claim. Question 505. If a deposit receipt states that a property is sold, as is, then a seller has no obligation to disclose material defects to the buyer. B. Seller still has an obligation to disclose material defects to the buyer. C clause does not apply if defects are not immediately apparent. D. As-is clauses are illegal in California. Correct answer is B. Seller still has an obligation to disclose material defects to the buyer. In California, and most other jurisdictions, an as-is clause in a deposit receipt or purchase agreement does not relieve the seller of the duty to disclose known material defects to the buyer. Sellers have a legal obligation to disclose any facts materially affecting the value or desirability of the property that are not known to, or readily observable by, the buyer. This duty arises from the common law and statutory requirements. An as-is clause generally means the buyer accepts the property in its current condition, including any visible defects. It protects the seller from liability for patent defects, those that are obvious upon reasonable inspection. However, it does not shield the seller from liability for latent defects, those that are hidden and not easily discoverable, that the seller knows about but fails to disclose. Question 506. The maker of a note could employ which of these legal defenses against a holder in due course? A. Duress influencing note agreement. B. Payment to redeem the note. C. Material changes. D. Either A or C. Correct answer is C. Material changes. A holder in due course, HDC, is someone who acquires a negotiable instrument, like a check, by giving value, in good faith, and without knowing of any problems with it. This special status protects the HDC from most of the original maker's defenses against payment, except for fundamental flaws with the instrument itself, real defenses. The HDC doctrine facilitates the smooth transfer of these financial instruments in business. A holder in due course, HDC, takes a negotiable instrument free of all claims. Defenses to an HDC claim fall into two categories. A. Real defense, which would include a material alteration, and could prevail against the HDC. Or, A. Personal defense, covering the other answers, which do not overcome an HDC claim. Real defenses, universal defenses, are defenses that are valid against all holders, including a holder in due course. A material alteration of the negotiable instrument is considered a real defense. Personal defenses are valid against the original payee or a holder who is not a holder in due course but cannot be used against an HDC. Duress, unless it's the extreme kind that renders the obligation void ab initio, and issues related to the underlying agreement fall under personal defenses. Payment discharges the obligation but isn't a defense against the validity of the instrument itself for a previous HDC. The key distinction lies in whether the defense strikes at the very validity of the instrument, real defense, or arises from the transaction with the original payee, personal defense. A material alteration affects the instrument itself, making it a real defense against an HDC. Question 507. Purchaser Pat made an offer through his broker to buy owner Oscar's home. Oscar accepted the offer, but Pat died before this acceptance was communicated to him by the broker. The acceptance is A. Binding on the estate of Pat, the deceased offerer, because the offer was accepted by Oscar, the offeree, establishing a contract. B. Not binding because the deceased offerer will be unable to enter into an escrow agreement. C. Not binding because the deceased offerer died before the offeree's acceptance was communicated to him, so no contract was established. D. Not binding because the deceased offerer cannot pay a commission to the listing broker. Correct answer is C. Not binding because the deceased offerer died before the offeree's acceptance was communicated to him, so no contract was established. Under contract law, an offer can generally be revoked by the offerer at any time before the offeree's acceptance is communicated to the offerer. Death of the offerer operates as an automatic revocation of the offer, even if the offeree is unaware of the death. In this scenario, Pat made an offer. Oscar accepted the offer. Pat died before Oscar's acceptance was communicated to Pat, the offerer. Since the acceptance was not communicated to the offerer while he was still alive, no binding contract was formed. The offer was terminated by Pat's death. Question 508. An owner advertises that he will pay a commission to any broker finding a buyer whose offer is accepted by the owner. This kind of open listing is A. Express and unilateral, B. Express and bilateral, C. Implied and unilateral, D. Implied and executory. Correct answer is A. Express and unilateral. The owner explicitly states their offer to pay a commission through advertising. This makes the agreement terms clear and communicated directly, not implied through actions. The contract is unilateral because the owner promises to pay a commission only if a broker performs the specific act of finding a buyer whose offer the owner accepts. The broker is not obligated to find a buyer, but if they do and the owner accepts the offer, the owner is then bound to pay the commission. There is no mutual promise of performance from the broker. A bilateral contract involves mutual promises between two parties. In this open listing, the broker doesn't promise to find a buyer. The obligation arises only if the broker performs the specified action. Question 509. The legal term that is only used to describe personal property left in a will is A. Devise, B. Bequest, C. Discharge, D. All of the above. Correct answer is B. Bequest. Discharge refers to the release of a debt or obligation. It's not used to describe property left in a will. Devise is specifically used for real property, land and buildings, left in a will, not personal property. A bequest refers to a gift of personal property, specified in a will. It can include things like furniture, jewelry, vehicles, or cash. Today, the two words are often used interchangeably. Question 510. Someone who is unable to swear an oath in a legal setting could choose instead to make an A. Notarization, B. Confirmation, C. Declaration, D. Affirmation. Correct answer is D. Affirmation. Notarization is the process of having a notary public verify the identity of a signer and witness the signing of a document. While notarization can be used for some sworn statements, it's not an alternative to swearing an oath. Confirmation can have various meanings depending on the context. It doesn't specifically refer to an alternative to swearing an oath. A declaration is a formal statement, but it doesn't necessarily replace the need for an oath. An affirmation is a solemn declaration that has the same legal effect as an oath. If someone can't swear an oath due to religious beliefs or other reasons, they can make an affirmation, which carries the same legal weight.